We are endowed by our Creator with certain unalienable rights, and that among those are life, liberty, and the pursuit of happiness. We are a nation of laws. Thomas Jefferson wrote those words in 1776. He was in an upstairs bedroom at the corner of Market and 7th Streets in Philadelphia, Pennsylvania. Those words are so powerful. It's the foundational principle of what this great country stands for. That foundational principle would later give us the United States Constitution. All premised on that each and every one of us have those unalienable rights. Our courts are supposed to preside over disagreements when a violation of those rights occur. Legislatures are supposed to pass laws to protect those rights. The executive branch is supposed to enforce those laws when they are broken. Those words that resonated so loudly in the Declaration of Independence still resonate today. Why? Because this foundational principle has existed forever. Since 1776, 248 years ago. All of us have a right to live. All of us have a right to liberty, to freedom. And we have them because they were endowed to us by our Creator. Have you ever chewed on the word unalienable? What that means? It means they're impossible to take away from us. They're not capable of being denied to us. They should not be denied to anyone because they're that foundational in what we all believe and stand for. The defendant stripped each and every one of those from Iyana and from Hazel. He now forfeits his right to life as he knew it. He now forfeits his right to pursue happiness. He now forfeits his liberty. But what should his sentence be? Should it be life in prison without the possibility of parole? Or should it be death? The defendant took the freedom of a 16-year-old young girl and an unborn baby. He took their pursuit of happiness. He stripped them of their ability to ever pursue happiness again. He took away IS's motherhood. He took away that unborn baby's daughterhood. IS lived the last seconds, minutes, or hours of her life at some point as her life was about to draw to a close with something that was about to happen to her that was atrocious, and it was cruel, and it was heinous. Even the defendant said he couldn't stomach it. IS would never go to school again. She'd never read that book again, any book. She'd never work at Chick-fil-A again. She'd never visit a neighbor across the street again. And the list goes on. Why? Because the defendant snuffed out her life. Because he himself, with his selfish interest that even his own doctor said, he's self-centered. He chose to kill two humans because he may wind up in jail sitting right next to those people he was talking to on the wire. He carried out a heightened premeditated plan. We'll talk about CCP in a bit. He did everything he could to get away with it. He tried to stay off cameras. He worked really hard to dump that body using bags or blanket, doesn't matter which. He somehow got her in that dumpster. He got rid of her book bag and her other bag and her underwear, and he got rid of her. He turned off his geolocation data. All this is going to go to what's called the cold, calculated, and premeditated aggravating factor. He deleted stuff off of his phone. He takes a gun with him to work. He went and got it out of wherever he had it in his home, and he put it in his red minivan, and he drove it to work that day. Cold, calculated, premeditated. And he goes and shoots at the gun range that afternoon on the 20th to blow off steam. All while IS and her unborn baby lay in a landfill somewhere. And then 22 days later, he's laughing it up in jail with two guys saying she's cooking out there. Cold, calculated, premeditated. Even he himself on that wire says this is a premeditated murder. Well, all that, ladies and gentlemen, begs the question, what is justice? This case is about to be yours, or the people, the most powerful entity in this great republic that we have. The people get to make the decision. Now you get to decide what to recommend to Judge Salem and hand him your recommendation. You get to do that. Now, you heard all the aggravating factors. If you notice in the penalty phase here, we didn't put any facts because you heard them all. And I'm going to walk through them in just a few minutes, but aggravating factors, quite frankly, ladies and gentlemen, think about the definition of them. The court's going to read the exact definition by Florida law of an aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim that's inherent in all first-degree murder cases. It's higher than all other first-degree murder cases when those factors exist. There are 6 of them in this case, 5 of which apply to each respective victim. As we walk through those, I'll explain that. The defense, as you now have seen, presented mitigating circumstances to you. And when you go through this process, you get to weigh those, so long as we prove it at least one. That's all it takes for you to move on to step 2. There are 2 major steps here. Did the state prove one aggravating factor to you beyond a reasonable doubt? And did they do so where you voted unanimously? We argue to you that all 6 have been proven to you beyond a reasonable doubt. Some based on your verdict. We'll talk about that. And then once you make that determination, you move on to the second step, which is, are the aggravating factors that you determine to be proven sufficient in of themselves to warrant the imposition of the death penalty? And once you answer yes and that answer affirmative to that question, you move on to that weighing that we spent a lot of time in jury selection talking about. And we ask you, can you meaningfully consider the mitigating circumstances that the defense presents to you? And you have to. You have to. That's why you're here. You went through an enduring process of questioning. and you will follow the law, because you've taken an oath that you will. We are a nation of laws. And you'll make this decision not because it's easy, it's not, it's hard, but because it's right, and it's just, and it is justice. And we'll talk about why in my argument to you. When you go back and deliberate this decision, base your decision on the law. Base your decision on the aggravating factors. Don't pull anything else in it. That victim impact testimony was extremely difficult, and we know that for you to listen to. Please, as the court made very clear, you cannot call that an aggravating factor. The law doesn't permit it. So please take only the 6 that we articulate for you and conduct your weighing with only those aggravating factors. If we are going to uphold the principle that Thomas Jefferson spoke about, that we all have those unalienable rights, they've been given to us by our Creator, what do we do when someone else, the defendant, takes those away? That is your question. What does justice look like? And the answer, quite frankly, ladies and gentlemen, is this: the defendant must be held accountable for his actions. He must be. We are a nation of laws. No matter whether you agree with who sits in the presidential office, some powerful words have come out of that office for the last 248 years. A modern day president said this: "We must reject the idea that every time a law is broken, that society is guilty rather than the lawbreaker. It is time to restore the American precept that each individual is accountable for his actions." The question is, will you hold him fully accountable? Not partially accountable, fully accountable. While the 3 branches of government have done their job, ultimately we are handing this case to you as the executive branch and handing it to you and saying, hold the defendant accountable for taking away IS's rights and their liberties, and her unborn baby's rights and her liberties. The real power does lie with you. When someone's life is taken, when someone's liberty is taken, when someone's pursuit of happiness is taken, we must address it and we must respond accordingly. Please note that the court will also instruct you when he gives the final instructions in just a little while. He's going to say to you, this is not a numbers game. It's a weighing process. So while it's easy to say, well, you're going to look at their list of mitigating circumstances, they'll talk to you about them. There's upwards of 20-something, upper 20s. It's not, well, who has more? Okay, so please make sure that is not part of your process. The court will talk to you about that. It'll talk to you about the weighing, the deliberative process that you must engage in. And it's simply this: did we prove to you at least one aggravating factor beyond a reasonable doubt? And you have to find that unanimously. Now, if you believe that of the 6 that we're going to present to you, that 4 of you were proven unanimously by you, that's the 4 you take with you and to conduct that weighing process. It's the proven ones. We believe we've proven all 6 to you. We'll talk about them in a minute. You take what you believe has been proven unanimously. This is your decision. Power is with the people now to follow the law. Why? Why must you follow the law? Because we are a nation of laws. Ladies and gentlemen, I argue to you this is the very definition of aggravated murder. It is. You convicted him of first-degree murder with premeditation when you found with your verdicts on count 1 and 2. Now your role in accomplishing justice is about to be completed with your recommendation that you're going to hand to the court. Well, what are these aggravators? Here's the first one. Let's take a look at your screens. The defendant was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. Note right underneath that, the crime of sexual battery is a felony involving the use or threat of violence to another person. You found that. You found that unanimously on Friday in count 3. That was previously, and that counts for purposes of this aggravating factor. There's the law in front of you. That's aggravating factor number 1. That's already been proven to you unanimously. That you've already found beyond a reasonable doubt. Now you just tally up your aggravating factors and go on to that second phase. That alone, with your verdict, in that verdict form, when you check the box for count 3, accomplished that aggravating factor. It's proven. Not because I say so, because you said so. And that was your verdict. And the state thanks you for that verdict. But that alone gives you aggravating factor number 1. Now, you can view that aggravating factor as to both counts. As to count 1, you can look at counts 2 and 3 and say not only did you convict him of first-degree murder, but you convict him of first-degree murder of the unborn baby, and take either one of those, count 2 or 3, and apply it to this aggravator, and it becomes more weighty. That's key here. It becomes more weighty. As to count 2, first-degree murder of the unborn child, you can take counts 1 and 3 and bring them into your calculus with respect to this aggravating factor. And that also becomes weighty. As to both counts, you'll make a decision as to both. The imposition of life in prison without possibility of parole or the imposition of the death penalty. You'll do that for both counts, count 1 and count 2. The question that you have is, how heavy are those? And the previous a felony involving the use or threat of violence to another person, you already found it twice. And that's a weighty aggravator. The second aggravating factor is that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. Obviously, this is with respect to a lawful arrest. Ladies and gentlemen, that was what the entire trial was about. When little IS at age 15 became pregnant on July 7, 2018, confirmed on December 13, 2018, by Dr. Atchu, you saw those series of painful Snapchats of what he was putting her through. The mental twisting about having this baby. I don't even know how I got you pregnant. I've been kicked down there so much. Remember that one? He did this for one selfish reason. He didn't want to go to jail for it. That's eerily similar to what we just heard today from a doctor. He's egotistical. He's self-centered. He's narcissistic, she said. And this aggravating factor heightens it. It increases the gravity of this crime or the harm to a victim because he's choosing something selfish to stay out of jail in exchange for taking away human life times 2. It's the whole motive. Quite frankly, with your verdict, you found him guilty of premeditated murder. This is inherent in that. How? It's the whole entire motive of the case, which we showed you repeatedly, not only with those Snapchats, but that wire. If that baby had been born, I'd be in here sitting right next to y'all. It was a chilling statement, ladies and gentlemen. That was a chilling statement. In essence, if I kill them, he's saying, I won't be arrested. And that's why this aggravating factor is weighty. That's why you will find it beyond a reasonable doubt. And that's why you'll use it also in your weighing process. Now, this aggravating factor applies to both counts 1 and 2. Why? Baby Hazel is who he wanted to die, so he wouldn't be arrested. If that baby's born, I'll be sitting right here with y'all. He had to kill IS because she was going to have the baby. So the aggravating factor applies to both. And it's weighty. And you get to weigh them. You know, listen, when you get to the mitigating circumstances and kind of conduct that weighing, you can call them wafer thin and light as you can tag them. You heard some mitigation today. I'm not going to spend a lot of time walking through that, but you heard a lot of mitigation. Well, you know, he didn't really get along with his father. You can attach very little weight to that when you pile these up. You can stack those mitigating circumstances to the moon, and they do not outweigh these aggravating factors, and we're only at 2 of 6. Now, third, this one has a lot of instruction to it. This is called the especially heinous, atrocious, and cruel aggravating factor. And Judge Salem will define it in detail for you. You're going to hear the words. Now, this aggravating factor only applies to IS. Why? Because this is who he said he strangled. You can't strangle the unborn baby, so we're not going to argue before you that this aggravating factor applies to Hazel, but it certainly applies to IS. Why? He chose to strangle her first. Listen very, very carefully here, ladies. Listen to the definition of this. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to afflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, and cruel is one accompanied by additional acts that show the crime was conscienceless or pitiless or was unnecessarily torturous to IS. Think about this, ladies and gentlemen. He somehow gets a 15, now 16-year-old girl to lure her to his work. He gets her in an area where nobody can see them, off camera, with a gun in tow. And he reaches up and starts to strangle her. While she's alive. His own brother on the witness stand said, well, yeah, he called me back and said, you know, he was frantic, he was panicky, he didn't know what to do. Called me back and says, it's been taken care of. What that tells us makes this aggravating factor proven. Why? Because she's alive when he placed his hands around her, and as he described it, he couldn't stomach it. Is it shockingly evil and extremely wicked to strangle a teenage child and then shoot her to death? Yes. Is it outrageously wicked and vile to treat a human being who's carrying what he thought was his baby like this and attack her like this in an industrial lot in the middle of the day when she should be at school carrying his child? Yes. Pretending like he wanted to take her out of town or run off with her. The poor little girl had underwear packed. And when she gets there off to the side, his hands or whatever he tries to strangle her goes around her neck. That's what he said. I'm not even arguing that to you. That's what he said. And oh, by the way, has his gun with him, knowing full well that she can't be gone long, not in that family. Not with those 5 hands who are wonderful people, and all they do is just, everybody knows everybody else what's going on. There's no way she's going to run off for any period of time, not be missed. We had to do it quickly. planned it a while. That's the next aggravator, CCP. We'll talk about that in a minute. But as to heinous, atrocious, and cruel, it was clear from the brother that he strangled her first. Do you think he did these things to her with utter indifference? Well, I'll say this. When he referenced to his brother he couldn't stomach it, he sure is laughing about it in the jail 22, 23, 24 days later. Indifference? You bet. A man capable of killing who he believes is carrying his child, and he couldn't stomach it. To strangle and then bring a gun to work, there's one purpose for a firearm, especially at that job on that day, and that was to kill her. And he tried a certain way, and it didn't work. He shot her. And that's what he said. Could have pulled his gun out and just shot her. That's not what he did. That's why that aggravating factor is before you. Pitiless and simply cruel. Now the next one, that's 3 aggravating factors, folks, and we argue those have been proven to you beyond a reasonable doubt. Here's the 4th one. Cold, calculated, and premeditated manner. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. Drop to that second paragraph. You know the first paragraph. You remember that from your guilt phase instruction. Look at the second paragraph. In order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. He lures her away from school. He coordinates a ride somehow for her. He gets his gun in advance. He takes his gun from his home and puts it in his pants or truck or his minivan. He drives it to work. He has a plan to get rid of her clothes, her books, her belongings, to get rid of her body, somehow to lure her from Terry Parker High School. He has the dumpster picked out because it normally gets picked up on Tuesdays or Wednesday. Much of this he's saying on the tape. He picks an area where it can't be seen on camera. He picks an area where his wife won't see that he's somewhere unusual, like way out in the woods on the north side or the west side. He picks an area that is off camera. He tells Iyana something, we're going to run away, or whatever it is he told her, to get her phone turned off, to hide that from the family. He turns off his geolocation data and then blends right in after he does his deed at work. That's why this is cold. It's calculated. It's premeditated. Listen to what he says on the tape. Man, were y'all fixing to run away? Yeah. Were you faking it? And the defendant goes, yeah. That's a plan. As his brother said. He told me he'd been planning it for months. If you read that second paragraph, that's all you need, folks. This aggravating factor, 4 of them have been proven beyond reasonable doubt. This is heightened, cold, calculated premeditation. Heightened premeditation. On the wire, you knew it was your baby. Well, I wasn't 100%, but you don't want to take that chance, said the inmate. Here's the defendant's response. Yeah. It's all about the baby. He wanted her and the baby dead. On the wire. I won't say the word. You've been effing her for how long? About a year, he said. We know when she got pregnant. Even the defendant, they ask, oh, what do you think will happen? You think you'll get the needle? You know what he says? Yeah, this is premeditated. That's what he said. The only conclusion from the evidence in this case is that he wanted them both dead. This aggravating factor applies to both. Count 1 and count 2. You can take this aggravating factor, you can pack it up and bring it to step 2 of your analysis because it's been proven beyond and to the exclusion of every reasonable doubt, and you should find so unanimously so that you can weigh it. This is the very definition. This fact is the very definition of heightened level of premeditation. The fifth, this is real simple. The unborn child of IS, Hazel, that is her name, was a person less than 12 years of age. I don't need to insult your intelligence. That's been proven beyond a reasonable doubt. That you should find unanimously. Now we're up to 5 that you can put in the hopper and weigh against that mitigating circumstances that were presented to you today. And the last aggravating factor. IS, Iyana, and the unborn child, Hazel, were particularly vulnerable because the defendant stood in a position of familial or custodial authority over IS or the baby. Folks, that's her uncle. He believed to be the father of that baby. He believed the baby was his. It's why we're even here. IS is over at the aunt's house, his wife's house a lot. She's over there sometimes alone. Naomi took the witness in and said, oh yeah, once a month or a couple times a month. It's kind of an as-needed thing. She came over a lot, and the nieces did a lot. Did they come alone? Yes. He made everybody dinner, and then he would give IS her own special dinner, as we heard, making them food. She'd be gone. Naomi would be gone out in her trucking job until like 2 in the morning. The defendant taught IS how to drive. He took her to the beach. He taught her how to swim against the current. He picked them up and dropped them off at school. There is no question he is in a custodial. He's 33 years old. Over this 15-year-old girl's life in his home. Carrying a secret that's what he believes to be his child. This most certainly is custodial authority. Not only as to IS, but that baby, he believes it's his. If anything on earth he should be protective over is who he thinks is his baby. That's why this is also an aggravating factor. And it should be weighty to you. Now, once you go through these aggravating factors, if you believe not all 6 have been proven, you can take 4 or 5 of them, still stick them on the hopper. Now, some, as you just heard, one of those does not apply to IS, one of those does not apply to unborn babies. So technically 5 you're weighing against each particular count. You have 6 in total, and that's what you're going to use in your calculus. Think about it this way, ladies and gentlemen. As you evaluate these, and as you weigh these, and as you attach weight to them, think about this. The defendant lured her to her death. The cold, calculated, premeditated plan. He lured her away. She had packed up underwear, and he packed up his gun. When she strolled out of Terry Parker High School on the phone, as you saw with your own eyes, he's in a few minutes going to turn his geolocation data off. Goes right to cold, calculated, and premeditated. Somehow she makes her way out to Ace. What's he doing? Getting bags or a blanket ready. It's cold. It's calculated. It's premeditated. While this little girl is living a confused life, trying to decide whether to have the baby, she eventually did decide whether to have the baby. They were going to have the baby. He, for months, is planning to kill her. That's cold. That's calculated. That's premeditated. In a heightened manner. He had so much time to reflect and just say, no, I'm not going to do it. But he did. While she made her way to him from Terry Parker High School to Ace that day, he's making plans how to get rid of everything. Cold, calculated, premeditated. As that all-American garbage truck carried her off to her grave, he's calling his brother, telling him he took care of it. That's cold. That's calculated. And 22 days later, as she's cooking in that landfill, he's laughing it up on the wire, confessing with his own mouth. Still trying to figure out a way to keep the authorities from finding her, planning in the jail. Hey, maybe I got someone on the outside. Go over there and move her. Remember that? Now that's cold, and that's calculated, and that's premeditated, and that's heightened CCP. Will you hold them accountable fully? Or will you hold them partially accountable? Now, you heard a lot about mitigation today. I'm not going to spend any time talking to you about it. But ladies and gentlemen, whether he fixes cars or helps a cousin, whether he makes go-karts for nephews, whether he encourages somebody to go to school, it does not outweigh. You can stack them all up. And you only have to find those by a greater weight of the evidence. Not the state standard, and it should be. We have to prove these beyond a reasonable doubt. You only have to find those by a greater weight of the evidence. Just presuming for a minute you find every one of those. You can stack them up on one side. They don't even come close to the weight of these six. Not even close. 6. 5 as to each victim. Paul Johnson, one of the most famous authors, great historian too, he wrote this about America, quote, "This is the greatest of all human adventures," end quote. And he said that, and he's right because of our government structure. And our government structure is so right, and everything works. We have these 3 branches of government because all the way back to when Thomas Jefferson said those words and made us a nation of laws is one of the reasons why we're sitting here today. You must be held accountable when you break those laws. Freedom comes with responsibility. The defendant had his unalienable rights. He's forfeited them. You found him guilty. One of those many responsibilities that we have as Americans, from paying those dadgum taxes to getting our licenses or paying your property tax bill, one of those responsibilities is don't hurt anyone else. Well, the defendant killed 2 people. He didn't just kill 2 people, he killed a niece. He killed a niece that he impregnated, he thought. And when you do these kind of things, you must be held accountable. That's what the criminal justice system is for. That's why we've done what we've done these last 2 weeks and a day, and we're handing this over to you. Now it is your turn to hold him fully accountable. Partial justice is partial accountability. Full, complete justice is full accountability. And if you really think, as I close, think about this. Justice is everywhere. We all strive for that. These systems that we sit in today, that you're getting to watch the judiciary, And the executive branch and the law with the legislative branch, you've watched it at work. And think about this. Justice is mentioned everywhere you go. I visited New York City recently, and in Theodore Roosevelt's childhood home, this famous quote he said is on the wall. The fundamental need in dealing with Americans, our people, whether laboring men or others, is justice. Right off the National Mall, Washington, D.C., you can go walk up and look at a Dwight D. Eisenhower monument, and plastered on stone is the following quote. We look upon this shaken earth and we declare our firm and fixed purpose, the building of peace with justice in a world where moral law prevails. You can walk just another mile and look up at the United States Supreme Court and it says equal justice under law. I started by quoting Thomas Jefferson for you. Listen to what Thomas Jefferson said about justice. Quote, the most sacred duties of a government is to do justice to all its citizens. Will you do justice? These verdicts that you handed down on Friday, coupled with these aggravating factors, cry out for justice. Bring the court back a recommendation to impose the death penalty for both count 1 and count 2 against the defendant. Because after reflection, after thought, you will see that these aggravating factors have been proven beyond a reasonable doubt. You will see that they outweigh every mitigating circumstances the defense is going to talk to you about, and then justice will be closer to being completed. Iyana and Hazel are gone. Their liberty is gone. Their pursuit of their happiness ended on December 19, 2018. A justice for her and her baby continues to this day. Complete justice for Iyana and for her unborn baby. Impose the death penalty on this defendant for killing these two humans.